All right, I think we can go ahead and get started. There are still some people filtering in, but I will try to multitask and admit them as I'm doing the introduction. I want to welcome everybody tonight. Thanks for coming. My name is Alamin Sumar, and I'm the Director of Social Outreach with the Capital Area Muslim Bar Association. And I want to welcome everyone to our panel event this evening. Does the Supreme Court have an anti-Muslim bias? This has to be the most important debate event happening in the country tonight. I can't think of anything else that's going on. And I'm going to introduce you to our rockstar panel in just a second and turn it over to our moderator, but I just wanted to make a few points before I do. The first is just to tell you a little bit about CAMBA, because there are a lot of folks on the call tonight who aren't CAMBA members. We're a professional organization, and our mission is to foster a sense of fellowship among diverse Muslim legal professionals and establish an institutional presence within the capital area legal community. We also hold events like this on topics affecting and of interest to Muslims. Check out our website. Please become a member. You don't have to be Muslim, and we'd love to have you. The second note is we know that there are some folks on the call, including one of our panelists, Asma Uddin, who will need to step away briefly during the event for Maghrib prayer. We encourage you to do that as and when you need to. The event is being recorded, so if there's some exceptionally interesting nugget that you miss, you can go back and check it out later. The third note is we'll have 15 minutes at the end for Q&A, so from about 7:45 p.m. onwards. If you have a question, just shoot me a private message over Zoom just to let me know. You don't have to send me the text of the question. And then when we get to the Q&A, I'll just call on folks who can unmute themselves and ask their questions in the order that I receive them. Lastly, please feel free to keep your video on during the session. It's always nice to see faces. I've done a few of these, and it's sometimes hard to tell how people are reacting to your comments. So please feel free to keep your video on, but try to keep yourself on mute if you can. And with that, I'll get to introducing our moderator and our speakers. So first is Adam Liptak, who covers the Supreme Court for the New York Times. He's a graduate of Yale College and Yale Law School and practiced law for 14 years before joining the Times news staff in 2002. In 2007, he began writing Sidebar, a column on legal affairs. And in 2008, he became the paper's Supreme Court correspondent. He was a finalist for the Pulitzer Prize in Explanatory Reporting in 2009. He's a member of the American Academy of Arts and Sciences. He has taught courses on the Supreme Court and the First Amendment at the University of Chicago Law School, the NYU School of Law, and the Yale Law School. Dan Mach is the director of the ACLU Program on Freedom of Religion and Belief. He leads a wide range of religious liberty litigation, advocacy, and public education efforts nationwide, and often writes, teaches, and speaks publicly on religious freedom issues. Dan currently serves as an adjunct professor of law at the George Washington University Law School, focusing on constitutional law and religious liberty. And prior to joining the ACLU, he was a partner at the DC office of Jenner and Block, where he specialized in First Amendment law. Sirine Shebaya is the executive director of the National Immigration Project of the National Lawyers Guild. She's a longtime immigrants' rights advocate who focuses on combining litigation and public campaign strategies to defend and advance the rights of immigrant communities of color. She's litigated several high-profile cases alongside and on behalf of communities impacted by the Muslim ban, family separation, discriminatory police practices, and immigration detention and enforcement. In partnership with local community groups, she led a campaign that resulted in eliminating ICE holds in most jurisdictions in Maryland. Sirine's work in advancing and defending immigrants' rights has earned her numerous awards. Lori Windham is senior counsel at Becket, where she defends religious freedom for people of all faiths, from the district courts to the Supreme Court. In addition to 4 Supreme Court victories, she has won more than a dozen victories in federal appellate courts, and her clients have included a Santeria priest prohibited from making animal sacrifices, synagogues prohibited from building on their own land, and the world's largest religious media network. As an expert on religious freedom issues, Lori has testified before the U.S. House of Representatives Judiciary Committee and the U.S. Commission on Civil Rights. Last, but certainly not least, Asma Uddin is the author of When Islam is Not a Religion, Inside America's Fight for Religious Freedom, and the forthcoming The Politics of Vulnerability, How to Heal Muslim-Christian Relations in a Post-Christian America. She is an Inclusive America Project Fellow at the Aspen Institute, where she is leading a project on Muslim-Christian polarization in the US. And she was formerly legal counsel at Becket. She's held academic fellowships all over the country, and she's an expert advisor on religious freedom to the OSCE and a term member of the Council on Foreign Relations. To put it simply, these are important people. Take it away, Adam.
Thank you, Alameen, and thank you all for joining us on a really provocative question against the background of a Supreme Court that almost everyone would agree is very much pro-religion, at least where Christian groups are involved. Let me sketch out just for a second to set the table what I think everyone would agree are the two major religion cases on the docket in the upcoming term, the term that starts on Monday. One of them involves a Catholic foster care agency, which seeks to be able to exclude same-sex couples from its work and to insist that the city of Philadelphia alter its contract, which ordinarily calls for non-discrimination on a number of bases, including sexual orientation. That's the case where, if history is any guide, the Catholic agency is likely to win and may, and we'll talk about this, may win big, may overturn an important precedent. The second case involves three Muslim men who say that they were abusively put on the no-fly list in order to coerce them to spy on their fellow Muslims, something they said their faith prohibited. And when they've sued under the Religious Freedom Restoration Act, the federal government takes the position that they're not entitled to sue for money. And again, if history is any guide, in cases involving lawsuits against law enforcement officials implicating national security, these Muslim men are likely to lose. Now, I may be wrong on both, but I don't think so. And it may not be a pattern. It may be coincidence that the cases shake out this way. But it certainly gives us some food for thought and things to explore. Let me give you a general roadmap of how we aim to proceed, I think, in descending orders of generality. I think I'm first going to ask a couple of panelists to talk about where the Supreme Court is on the First Amendment's protections of religious liberty at the most general level, and then to look backwards and forwards at some of the cases on the docket from the last term and this term, and see how those illuminate where the Supreme Court is on religion, and then to bear down on the question that's the provocative questions that's the subject of this panel, is does the Supreme Court treat minority religions, and Islam in particular, differently than it treats the dominant religion? I have encouraged the panelists, in addition to giving brief comments to set the table, not to wait for me to ask questions, but to respond to one another and keep this a free-form, free-flowing, robust discussion as we go along. But we're going to proceed in that general order. And as Alameen said, we are eager to have your questions toward the end. Lori, may I ask you to start at the most general level of what can be said about the current Supreme Court as regards religion?
Sure, and thank you, Adam, and thanks everyone for this event. It's going to be a really interesting discussion. So I wanted to start with 4 higher level observations about what we've seen from the Supreme Court in recent years, which I think is helpful when we're thinking through where some of these cases involving the Muslim community have gone. And so the first thing we've seen is a shift in the Supreme Court's Establishment Clause jurisprudence, where, you know, we all in law school were taught about the Lemon test and then the endorsement test, which was kind of the gloss on that. And the court has really strongly moved away from that in the last few years and instead has looked more toward historical Establishment Clause interests. Is the government taking over something that was historically religious? Is the government interfering and involving itself in religious matters? These are the kind of things that the court has focused on more. And so claims of religious discrimination, which for a long time have been brought and litigated as Establishment Clause claims, instead we're seeing brought and litigated and decided as free exercise claims instead. Which brings me to the second overall trend we've seen, which has been really vigorous enforcement of the free exercise clause. We've seen that in the Trinity Lutheran case, in the Espinosa case, in the Masterpiece case, where the Supreme Court really has looked very carefully at the government rules that are involved and for lack of neutrality between religious groups or between religion and non-religion. The third trend that we have seen is strong enforcement of federal laws protecting religious freedom. So the Religious Freedom Restoration Act, or RFRA, the Religious Land Use and Institutionalized Persons Act, or RLUIPA. There we have seen the court apply those, and including apply them in Holt v. Hobbs to protect a Muslim prisoner and his ability to wear a beard. And we've seen them apply it in other cases, including Hobby Lobby and Little Sisters of the Poor. And so the court, and I should go back a little further and mention the Ocentro case as well, where it carved out an exception to the nation's drug laws for a Brazilian group. And so we've seen really strong enforcement of the federal religious freedom protection laws. And then we have a cross current going on, which is the fourth thing I'll mention, which is that the court has also been very concerned about procedural issues, about standing, about all the stuff that you study in federal courts class. And so you see some cross currents in some of these cases. The Little Sisters of the Poor case decided last term was an Administrative Procedure Act case. It also involved RFRA and religious freedom claims, but this is something that came to the court under the APA. And this is something that I think is going to be important as we're looking at the Tanzin case as well, because you have, on one hand, the court's strong enforcement of RFRA, which is at issue in that case. On the other hand, you have the court's skepticism toward limiting sovereign immunity and some of these other procedural protections or procedural hurdles in some cases. And so those two things are really coming head to head. In the Tanzin case, I hope that the court will rule that these gentlemen are able to vindicate their rights and sue and recover damages. That's what we've asked the court to do. But we're going to have to wait and see how those different interests of the current court really play out when they butt heads in that case. And briefly, as Adam has mentioned Fulton. I think Dan and I on opposite sides of that will be some of the very few people who are awake early in Washington on the day after the election for the Supreme Court to argue that one. As Adam mentioned, this involves not only the rights of foster moms and a religious foster care agency, but it involves a bigger question of how is the court going to understand free exercise claims going forward? Is it going to really focus on whether the law is neutral and generally applicable? I think there's a lot of reasons why Philadelphia's law here wasn't. But is it going to hold to that standard, or is it going to go back and revisit the 1990 case of Employment Division v. Smith? And so it's going to be fascinating for all of us to see where these things go over the next few months.
Well, thank you. And Dan, I'm supposing, but you'll tell me, that as a descriptive matter, you will agree with much of what Lori sketched out, even as you find yourself on the opposite side of her in many of the cases you guys litigate. But why don't you give us your take about where the court is and is heading? And I wouldn't mind diving a little more deeply into the Fulton case, because it could be an authentic landmark case, and maybe you could unpack that for us as well.
Sure, and I think in general, yes, I agree with how Lori sketched out the trends. We may be rooting for different things. She may be happier about the trends than I am. One thing I guess I would tweak a little bit is I don't know that I wouldn't say that the court is on Establishment Clause matters is returning to a historical analysis. I think it is inventing a new historical analysis. But I do agree that the current court has regularly embraced free exercise claims. whether statutory or constitutional, and at the same time has steadily chipped away at the Establishment Clause and the separation of church and state. And we've seen this in a number of areas. I know we're going to talk more about some of the specific cases, but just a few of the areas. One is government-sponsored prayer, where the court has in recent years allowed much more than it did before. That is also true with respect to government-sponsored religious displays, where in the past the court has been much more skeptical of the government displaying prominent religious symbols as the government. Normally, in the past, the court has said that government can't send a message that we, the government of the people, like this religion or that religion best. But just last year, the court did allow a giant religious display of the preeminent symbol of Christianity. Another area where I think we've seen this trend of sort of chipping away at the Establishment Clause is in the funding cases. It used to be that these cases were generally about whether states could fund religious institutions and religious schools consistent with the Establishment Clause. Now the question is not whether it's okay for states to do that, but whether states must fund religious institutions with taxpayer dollars. And again, the recent decision, the Espinoza case, the court ruled that in certain situations, yes, the state does have to fund religious institutions. That's a dramatic shift from where we had been. I'll talk about Fulton in a moment. I just want to say on this trend, on the Establishment Clause side, the question of today's panel, I think, is how are Muslims treated in the Supreme Court? And I want to make one thing clear. We're going to talk about cases in which Muslims were the actual plaintiffs. But even beyond that, the systematic dismantling of the Establishment Clause, which is what's going on, I think, is a direct threat to Muslims in the US and to all other religious minorities, not only minority faith, but also the non-religious. I mean, I think, jurisprudence that embraces, for example, religious displays, especially old ones, will undoubtedly favor Christian displays. And a constitutional regime that permits government-sponsored invocations will tilt heavily toward official government-endorsed Christian prayer. And similarly on the funding, forcing state taxpayers to subsidize religious institutions and activities will principally benefit minority faith institutions. And that is what we've seen in our history, and I think we're going to see more of that. So I think it's important to keep in mind with the overall question about today's panel, how will the chipping away at the Establishment Clause affect minority faith adherence? And I think negatively is the answer. I don't know if you want me to.
We want to pause on that and see if anyone has a response to that. It sounds like a fair point that the stronger Establishment Clause will tend to favor the dominant religion, particularly when so many of the monuments in question, for instance, are old when the nation was much more predominantly Christian. Does anyone take issue with that point?
Well,
apparently not.
I think just to the extent that you have an analysis that's favoring monuments that have been around for a long time, yes, I mean, definitely Christian monuments have been around a lot longer than any other monument, right? Just by nature of the history of this country. So on that front, I would agree. But I think there's a bigger question also about the Establishment Clause, or the tests that are being preserved and the array of and context in which that test is being applied, and the way that that sort of treats religion and sort of it requires the government, the court to sort of undertake subjective inquiries and that sort of bigger process and the principles that are at play, I think ultimately something that's more religion favoring is something that will favor minority religions as well.
But consider this thought experiment, and it's not wholly a thought experiment. What if a minority religion wanted to erect a monument to its religion next to a Ten Commandments monument? That case came before the court. The minority religion was Sumum, as I recall, and it had 7 tenets. And the court managed through some gymnastics to say the Ten Commandments was fine, but the minority religion was not fine. And similarly to the thought experiment, if let's say some town in Mississippi decided it wanted to put up a monument to any minority religion, any non-Christian religion, it's not clear that the public would stand for it and the courts would allow it. Or am I missing something?
And I think we've had a couple of different lines of analysis that have come in. You know, Sumum was a forum case rather than an establishment clause case, and seemed like from some of the opinions on the court, they would have liked to have seen that as an establishment clause case. I think that when you're looking at these kind of religious displays, it depends in part on how they're analyzed and how they've been put up. You know, there's a lot of discussion in the American Legion case about the fact that you have Stars of David prominently marking the graves of Jewish soldiers, and that's always been understood to be, you know, acceptable, just as the Bladensburg Cross there was acceptable. But I think another feature of the Establishment Clause that gets overlooked is the way the court has used that in a religion protective way in the ministerial exception and church autonomy cases. And so if you see the Our Lady case and Hosanna Tabor case, those were cases involving Christian groups, and yet they were in part reactions to some things that had happened below in a series of synagogue cases in the Ninth Circuit and elsewhere that had created a circuit split. And you see Justices Alito and Kagan coming together in Hosanna Tabor to write a concurrence saying, hey, I know we're talking about ministers here, but that's a legal term. It's not a religious term. It involves, you know, it also covers rabbis and imams and teachers of many faiths. And so I think there's this corresponding shift in the Establishment Clause when you look beyond just the display cases to also have non-interference rules that can benefit a wide variety of religious groups.
Fair point. And it's true that in the ministerial exception cases, several justices went out of their way to say minister is a term of art in Christianity, and the analogs in other religions ought to be protected as well. Dan, I sort of cut you off as you were about to tell us some more about the Fulton case.
Yes, and thank you. Before Fulton, just one point on that. When we're talking about the Establishment Clause and the defanging of the Establishment Clause, we have to keep in mind not only what the question is not only what does the court think is acceptable or not, but if the court essentially opens the door, then we are left in many of these instances, and some cases not so, for example, ministerial exception, but not just displays, but government-sponsored prayer and funding and things like that. Then it's left up to the democratic process. So if you take the example of government-sponsored prayer at, say, city council meetings, if the rule is every member of the city council can take turns giving a prayer in their own faith tradition and can be as sectarian or as explicit within their faith as they want, then you're going to have majority rule. So if the courts just stay hands off, then what you're left with is, well, who are the elected officials that get to decide which prayers they're going to give? And then I think we fall back to, it's a clear favoring of the majority in that situation. As for Fulton, this is, as Lori said, this is a case that we are on opposite sides of, and we are eagerly awaiting the argument the day after the election. So that should be fun. But briefly, this is a religious foster care agency, Catholic Social Services, argues that it has a right to discriminate against prospective foster families using taxpayer dollars when performing a government service. In other words, they argue that they have a free exercise and a free speech right to get a government contract to perform a core government service, which is certifying foster parents, and to change the terms of that contract to be able to discriminate, to turn away qualified families. And there are many concerns here, but I mean, essentially this could allow taxpayer-funded agencies across the country to turn away qualified families who don't meet their religious tests, whether because they are LGBTQ or of a different religion, and there are a number of examples of that, or whether they don't go to church or for any other reason. So it's a claim that the lower courts have rejected, but you know, it is cause from my perspective of concern, what a ruling in that case against us could lead to.
So Dan, I think there are two different ways to frame it. One is that this is a government contract and the government should be able to set the terms of its contract, particularly for something as uncontroversial to many people as please don't discriminate. Don't discriminate on the basis of race. Don't discriminate on the basis of sexual orientation. Another way to think about it, though, is that Catholic foster agencies have done this work for millennia. And just because the government comes in and occupies the field and says, we're going to run things now, they should not be made to run their important social work in a way different than their faith commands. How do you respond to that conception of the case?
Yeah, well, I think we have to keep in mind what the field is that's being occupied. So this has nothing to do with, for example, private adoptions. This is just foster care, which is the state, which has been going on for a century at this point. The state steps in, removes children from their homes for safety or other reasons, and now those kids are in the care of the state, or the city in this case. And in that situation, the fact that it may have been done differently a century ago, I don't think matters, and for constitutional purposes, shouldn't matter. The question is now that the government is doing that and has been doing it for a while, can they insist on certain basic non-discrimination rules? Again, with taxpayer dollars, performing what is a core government service right now.
Lori, I feel like I should let you respond, but also let me ask you a question you can deal with at the back end of your comments. What if the foster care agency wanted to discriminate on the basis of race, to say that interracial couples are not fit foster parents? Would that be analyzed differently?
Sure, Adam. And to take the first question first, I think that it would. The Supreme Court's been pretty clear in Bob Jones and Loving and other cases that the government has a compelling interest in preventing and prohibiting race discrimination. And I think that the courts would very quickly rule in the government's favor in those kind of cases. When we're talking about foster care, we are talking about work that has been done by religious organizations for hundreds of years. The Catholic Church in Philadelphia pioneered this work, and it's still done primarily by private organizations today. The government in Philadelphia decides where children go, but it depends on an entire network of 30 different private foster agencies to find and support and help and accompany these families. And so Catholic Social Services, partnering with women like Sharon L. Fulton and Tony Sims Bush, wants to continue doing the great work it's been doing for many years. It's particularly concerning here the way Philadelphia has gone about what it's done for a couple of reasons. One is they didn't have a clear rule that actually applied in these circumstances. Foster care is not like buying a sandwich. You consider race, you consider gender, you consider sexuality, you think about these things when you're trying to find a family for a child. And so when the city came in and said, hey, it's our public accommodations law that applies here, nobody's allowed to consider that stuff, they had to admit that they actually themselves were making those same kind of considerations in foster care. So there wasn't a clear rule that applied under the Supreme Court's precedent, under Lukumi, even under Smith. That is something that gets strict scrutiny, and I don't think the city can pass strict scrutiny here. Second, Philadelphia's actions here were way over the top. The city admitted that it had 250 children who were in institutions and needed family homes. And when it learned about Catholic Social Services religious practice, it refused to place any more children with their families. And so women of color like Sharon L. and Tony weren't able to take in extra kids, even kids the city admitted they needed to move out of institutions into family homes. There was also an incident with a special needs child who was separated and not able to return initially to his former foster mom who wanted to adopt him just because she worked with Catholic Social Services. And so I think what we've seen here is a real overreach by the government in trying to crack down on a religious belief and religious exercise that has been carried out for a long time. And so I think that the court is going to be very much aware of and concerned about that series of facts.
So you guys have demonstrated that this is a rich enough and interesting enough case we could spend the entire session on it. And also that it's kind of a tragedy that it'll be argued on a day that no one will pay attention to my story on it. Let's broaden out the discussion and maybe look back a little bit, get a little more granular at the cases from last term and what they might tell us about where the court is headed. Asma, can I ask you to, first of all, react to whatever you might like to react to, but also tell us a little bit, not only about the where we're going, but the where we've been.
Sure. Well, so far we've sort of mentioned in passing some of these cases, the Espinoza, Little Sisters of the Poor, et cetera. I just want to take a minute to sort of explain what these cases were and some of the details. So the first one, Little Sisters of the Poor versus Pennsylvania, it was decided in July. It was the latest installment in an ongoing battle over the ACA's regulations that were issued by the Obama administration. The contraceptive mandate part of the ACA required employers to include no-cost contraceptive coverage in their employee health insurance. And so Little Sisters was one of many, many cases that arose across the nation when that mandate was applied to religious organizations that have a religious objection to contraception. So the Obama administration provided what it called a self-certification accommodation, which allowed the religious organization's insurance plan administrator to provide contraceptive coverage directly to the employees. The religious organizations had to communicate their objections to the insurance administrator, and the administrator would then provide the coverage directly. But many religious employers thought the accommodation didn't go far enough. They said that according to the complicity doctrine in their religion, simply sort of like the process by which they had to communicate the objections implicated them in something that was against their religion. So there were lawsuits all over the country seeking protection under RFRA, but the government prevailed in almost all of those cases. Courts held that the accommodation did not impose a substantial burden on the religious organization's exercise of religion. In the 2016 case, Zubik v. Burwell, the court unanimously reversed those decisions and remanded to give the parties an opportunity to come up with a solution that worked for both the religious organization and also made sure that it got the drugs to the women, to the female employees. In 2017, the newly elected Trump administration issued regulations exempting the objectors from the contraceptive mandate, essentially treating all religious nonprofits the way churches are treated. And the administration claimed that it had statutory authority to issue these regulations under both the ACA and under RFRA. Pennsylvania sued and argued the administration did not have authority, but the Supreme Court in a 7-2 decision held that the administration did have authority under the ACA and that therefore there was no need to weigh in on the RFRA argument. And so the matter is still being litigated. It's been sent back to the lower courts to determine whether the Trump regulations were arbitrary and capricious. Another case that we've mentioned a couple of times is the Our Lady of Guadalupe School case. It was consolidated with a very similar matter involving the St. James School and centered on a doctrine known as the ministerial exception. The ministerial exception bars ministers from suing churches and other religious institutions for employment discrimination. So Agnes Morrissey-Barrow and Kristen Beal were elementary school teachers at each of these Roman Catholic schools. Morrissey-Barrow taught at Our Lady. She alleged that the school had replaced her with a younger teacher in violation of the Age Discrimination in Employment Act. And Beal taught at St. James School. She claimed that she had been discharged for requesting a leave of absence for breast cancer treatment in violation of the Americans with Disabilities Act. Both of them had religious responsibilities as teachers. Morrissey-Barrow, for example, was a primary teacher for the 5th and 6th grade classes, teaching them all the subjects, including religion. She taught them the sacraments, the prayers of the church, biblical stories and Catholic doctrine, and prayed daily with her students. But at the same time, she didn't have an official position within the Catholic Church. The school did not require any background or training in Catholic education. And during the litigation, she said that she was not a practicing Catholic at all. So the facts in the Beal case were similar. And so the question was, do these teachers, people who don't have actual official titles, do they constitute ministers for purpose of the ministerial exception? And in a 7-2 decision written by Justice Alito, the court held that both women were covered by the exception. The lack of title didn't matter, the court said, because, quote, since many religious traditions do not use the title minister, it cannot be a necessary requirement. Attaching too much significance to titles would risk privileging religious traditions with formal organizational structures over those that are less formal. And the court said what matters at bottom is what an employee does, because especially somebody who's training the next generation in a religious school obviously sort of carries a lot of religious importance. Another religious case from last term was the Espinoza v. Montana Department of Revenue case that was decided in June. It was a 5-4 decision, and the court ruled that the state of Montana cannot exclude religious schools from receiving tax credit funded scholarships under its school choice program. Montana had excluded religious schools because its state constitutional no aid provision prohibits, quote, any direct or indirect appropriation or payment from any public fund or monies, and to aid any church, school, academy controlled in whole or in part by any church, sect, or denomination. And so the court addressed both the establishment and free exercise clauses of the First Amendment. On establishment, the court upheld previous findings of school choice programs supporting religious schools do not violate the establishment clause. And on free exercise, the court found that programs that exclude religious schools do violate the free exercise clause. And in reaching that free exercise decision, the court distinguished between religious status and religious use. It said that to be, the fact that the Montana no aid provision essentially made ineligible these programs that are religious just in their status, that's status-based discrimination, as opposed to, for example, what we saw in Locke v. Davie, where the state prohibited the use of state scholarship money to be used specifically for a theology degree. They said that was okay because that was a religious use of the money. And finally, the case that, where this panel is sort of centered around is the Thenvier v. Tanzan case. Adam went over some of the sort of details of that case, but the specific issue is whether the plaintiffs can sue the FBI agents for money damages under RFRA. And importantly, it's sort of turning more to sort of the bigger theme of today's panel. What I find interesting is that being able to sue for money damages under RFRA is important not just to the Muslim plaintiffs in Thenvier, it's also important to any religious believer who seeks to vindicate his or her rights under RFRA. Right, so without financial liability, government officials can game the system by limiting people's religious practices, but then when sued, eliminate the restriction only to impose it on the next similar religious believer. And so this is sort of gamesmanship that is threatening to a wide array of religious believers, including Christian believers. And so what I find interesting is some of the sort of the way that the alliances are sort of lined up around this case. On the one hand, you have the Trump administration, which has abandoned its usual role as defender of Christians' religious interests and asked the court to dismiss the suit because it would interfere with sensitive matters of national security and law enforcement. And on the other hand, groups that usually support conservative Christian claims have filed briefs in favor of the Muslim plaintiffs, urging the court to adopt their broad interpretation of RFRA. There was also a really interesting piece in Vox earlier this year talking about the dilemma this creates for some progressives. It said that progressives who are normally supportive of Muslim plaintiffs have mixed feelings about a potential Muslim win in this case because it will pave the way for Christian conservative wins in the future. Specifically, they're concerned about cases like the Masterpiece Cake Shop case, where a Christian baker declined to bake a cake for a wedding for a gay couple. They worry that a reading of RFRA that permits Thenvier to sue federal officials means, and the Vox writer wrote, that federal officials charged with enforcing many anti-discrimination laws could risk financial ruin if they bring an action against someone who claims that their faith requires them to discriminate. So I think it's interesting. It's got a cross-cutting legal issue, and the way that just the different groups have lined up in this is different from what we usually see. And I wonder if it sort of opens the door to sort of more nuanced conversations around religious liberty moving forward. Thank you.
That was a terrific summary, and I have half a dozen questions I could ask, but I think we want to keep the discussion moving, although some of the points you've made, and particularly the last case were so interesting. I'm sure we'll return to them. But let me get Sirine involved in the conversation to get a reaction and maybe to broaden it out about what else we've seen from the Supreme Court in the context of Muslims, notably in the travel ban case.
Thank you, Adam. Yes, I think maybe what I'll do is start with a higher level comment about the makeup of the court and how that influences the issues that the court sees as real or meaningful. And I think that that's true both in the religious liberty context and in other contexts where, the decisions that the Supreme Court is making are not being made in a vacuum. They're being made against the experiences of the justices who sit on the Supreme Court and what perspectives that reflects. And I actually think that that is not an insignificant point. This is outside the topic a little bit, but I think that it will be very interesting to see, for example, to the extent that this continues or grows, how the Supreme Court will look upon different kinds of RFRA claims, for example, in the context of the sanctuary movement, or causes that the Supreme Court has not actually looked favorably upon so far, at least in its current makeup. Drilling down from that sort of higher level point to this question of how the Supreme Court has treated Muslim plaintiffs versus, or litigants versus other religions, I think one of the most striking examples of a quite astonishing divergence or inconsistency was in the 2018 term, where the court decided within a couple of weeks, both the Masterpiece Cake Shop case, which was about a Christian baker who did not want to bake a cake for a gay couple's wedding, and the Muslim ban or travel ban case, which was about obviously the an executive order or proclamation at that point that was enacted subsequent to very virulent and overt anti-Muslim comments from Trump, starting from the campaign trail and continuing into his time as president. So in the Masterpiece Cake Shop case, we had a situation where the court looked at any subtle departure from neutrality. Those are the words that Kennedy used in his opinion, that any subtle departure from neutrality or any sort of like appearance that the people adjudicating a matter like this had hostility towards a particular religion, that was completely unacceptable, and that it kind of colored the entirety of the Colorado Civil Rights Commission treatment of that case. So the comments at issue there, sorry, I lost my place here. So the comment at issue there that Justice Kennedy thought revealed animus towards the Christian religion or towards the religious beliefs of the baker was that a commissioner said, I would also like to reiterate what we said in the hearing or the last meeting. Freedom of religion and religion has been used to justify all kinds of discrimination throughout history, whether it be slavery, whether it be the Holocaust, whether it be, I mean, we can list hundreds of situations where freedom of religion has been used to justify discrimination. And to me, it is one of the most despicable pieces of rhetoric that people can use to use their religion to hurt others. And Justice Kennedy found that comment, which was actually in that context, a stray comment that was not directly related to the merits of how the Colorado Civil Rights Commission decided that in the public sphere, discrimination on the basis of someone's sexual orientation was not acceptable. That was the basis on which Justice Kennedy found that was a free exercise violation, because the lack of respect that was shown, or the lack of neutrality on the part of the public official in that straight comment, was sufficient to sort of color the entirety of the commission's decision, which was very well reasoned, and there were multiple commissioners and all of that. I'm dwelling on this because I think that it probably goes without saying, at least in this crowd, that the long string of comments that Trump had made about the Muslim ban, about how he was going to have a total and complete shutdown of Muslims coming to the United States, where while he was president, he was retweeting these extremely vile and sort of racist tropes about Muslims, where he told this story about General Pershing, who would kill Muslims and then put like pig's blood all over them. I mean, things that are just absolutely and very directly reflective of animus towards Muslims. But yet in the Trump versus Hawaii case, the court didn't find that to rise to the level of something that evinced discrimination on the basis of religion. And it chose to sort of disregard that very, very well, well-documented record of overtly anti-Muslim statements, and not like a stray comment about how sometimes religion is used to discriminate against people, as something that didn't rise to that level, and it was completely fine. And the Muslim ban was allowed to continue because of the words on the four corners of the paper somehow standing on their own didn't, to the Supreme Court sitting at that time, evince that kind of discrimination. And to me, that's actually very much a reflection of a Supreme Court's jurisprudence that is not about religious liberty per se, but about a certain view of religious liberty, or a certain view of religious exercise even, that is both hostile to certain religious minorities, but also hostile to different views about what religion might mean. I think that very shortly thereafter, like in early 2019, there was a case of a Muslim man on death row who had tried to have his spiritual chaplain present in the execution chamber. And in that facility, it was very common for the Christian chaplain to be present, and that person was always allowed to be present. And this person, who was a devout Muslim, had asked for his Muslim spiritual advisor to be present in the execution chamber at that time. And in that case, the 11th Circuit had actually granted a stay of the execution to look at the merits of the Establishment Clause claim. And the Supreme Court kind of like reached, under a very difficult standard, right, like an abuse of discretion standard, reached to overturn that stay and say that the man could be killed without even a chance to argue the merits of whether the fact that he couldn't have his spiritual advisor with him in the execution chamber, did violate the Establishment Clause, and just outright denied the stay. The reason was a procedural reason about the fact that he waited too long to bring his claim, even though he actually brought his claim 5 days after he learned that his advisor would not be present in the room with him. So I think it just reflected a lack of kind of understanding of how those things actually intersect to deprive people of different religions of their rights. And it reflected a sort of casual disregard of the sincere religious beliefs of a person who is Muslim, who wants someone with him in the execution chamber, just like someone who is Christian might. I'll stop there. I'm sure there's going to be many disagreements with what I just said, but.
Well, thank you. You've said a ton of interesting things, and I put them into two buckets, and I want to deal with each of them. But let's deal with the second bucket first, and I want to draw Lori into this because Becket did some very important work that I think moved the court to at least come up with some neutral principles in the context of death row inmates seeking to have spiritual advisors. I don't think anybody on any side of the aisle was happy with the way the court treated that case. I don't think inside the court they were particularly happy with how they treated it. These emergency applications often don't get the attention and deliberation they deserve, and this was a key example of that. But Lori, let me ask you to talk about that case and a subsequent case involving a Buddhist inmate, and tell us whether the Supreme Court has more or less found at least a neutral place on all of this.
Certainly. As you mentioned, there was it was 2 weeks after they had denied the opportunity for the Muslim inmate to have an imam with him at the moment of his death, that they granted a similar petition allowing a Buddhist inmate at least the opportunity to be able to have a spiritual advisor. As I understand, that case is still working its way through the lower courts. This came out of Texas, and Texas has since changed its policy, although not as much as it should have, and that case is still kind of working its way up, but the inmate was able to get the stay. And I think that, as you said, there was widespread outcry and concern over the way the court had decided this case on, a very quick basis and a bare record. And I think it shows in part the difficulty and the risk when the court is having to decide these really important issues under emergency circumstances. But after that outcry and after some more consideration of that, the court did then decide that it was at least going to consider these claims and look at the treatment of inmates across the system and whether there's actually comparable options made available for those of different faith groups. Our position has been that we think that an inmate should be able to have a spiritual advisor or clergy member with him or her at the moment of death. That's something that has been honored and respected throughout the ages. The court hasn't yet gone that far. Instead, it's looked more toward equal treatment, neutral treatment. But I'm hopeful that going forward, it will emphasize a neutral treatment rule for Muslims and for all others. And that we'll see a little bit more recognition of the importance of protecting inmates in those cases. And I think that this shows that the court, agree or disagree, really has placed a strong emphasis on procedure and how it's going to look at these issues going forward. So I'll be really interested to see how this comes up, because this issue is going to land on their doorstep again, and probably in the guise of an emergency petition again.
So where we seem to be now is you don't have a right to a spiritual advisor, but if somebody else is getting a Christian spiritual advisor, you should be able to get a spiritual advisor of your faith too. And that may not be the best outcome, but it's certainly a better look for the court than to say that Christians get spiritual advisors, but Muslims don't. But the very fact that they would go there, even briefly, and even in this context, is a troubling note. Does anyone else want to talk about these death cases before we move on?
Just to add on to that, I think that's one area where we are in sync, probably all of the panelists here, and we have, at the ACLU, have done some cases. We did some cases related to the right of clergy to minister to death row inmates who were being subjected to the federal death penalty, which has just been revived. That we were unsuccessful ultimately there too. But I think that, the downside for the state is zero in being able to provide this, and I agree with everything that was said. Adam, Lori, et cetera, that it was a very bad look for the court to change its mind so quickly. And the reason given in the first case was all about timing, and it just didn't hold up at all. I think Justice Kagan in dissent just blew that out of the water. So hopefully the court has turned the corner. And just one final thing on that, there is the federal statute, RLUIPA, which gives extra protections for incarcerated people. So that should be enough. I mean, yes, obviously the differential treatment is bad enough, but I don't even think that we need to make that argument, or we should have to make that argument, because there's clearly a burden in the final moments, and the state's argument for why it can't do that is flimsy at best.
So let me return to what I called the first bucket, which is to see if it's possible to reconcile the Masterpiece Cake Shop comments and President Trump's comments in the travel ban case. And let me offer two ideas, neither one of them wholly satisfactory, but maybe people have other ideas. One is that Justice Kennedy's reliance on the stray comments from the commissioner seemed to have been plainly a make-weight in order not to decide the fundamental question in the case, a question that might be more directly decided in the Fulton case, of what do you do if there's a clash between claims of religious liberty and equal protection principles. And the court was looking for an off-ramp and didn't give us a definitive decision, and this was the best they could do. Second, in the travel ban case, I think if that case reaches the court a year or two later, there would be less patience with the Trump administration's tactics. As we saw when the Trump administration tried to add a citizenship question to the census, Chief Justice Roberts, joined by the four liberals, said that they were willing to look beyond the four corners of the proclamation, the whatever it was, and take account of whether it was pretextual. And just now in the DACA case about whether young immigrants known as dreamers should be afforded protection, or whether the Trump administration could withdraw that protection, similarly, the same coalition said, we're not going to take you at face value, we're going to look behind what you've done. So I think some of this is contextual, but that doesn't really get you to harmonizing the two cases. Does anybody think they can be harmonized, or is it simply different treatment depending on the religion involved?
Well, I think different from the census and the DACA cases that you brought up is the question of national security and foreign policy, right? And so a lot of the Supreme Court's opinion in the travel ban case was based on this idea that's fundamentally different from the Masterpiece scenario, because we're not just talking about looking at the intentions of like this mere commissioner on the Colorado Human Rights Commission, but we're looking at the president, and these are specific areas that the law says we just need to completely stay out of. So I think it was also just, like the area, the topic area, and the fact that there is such strong deference that's supposed to be given to the president in that particular arena.
Yeah, I think that was the main reason given by the court in the Muslim ban case. was basically that in this area of national security and immigration, we just give such great deference that we're just not going to intrude. There are a few, but I don't think the cases can be reconciled. I don't buy it. I think, as Sirine said, that the comments in the Masterpiece case were made by 2 of 7 commissioners who were part of a long chain of events, many other decision makers involved. Here, it was one decision maker. He admitted exactly what he intended to do, and they let him get away with it. I think one of the especially embarrassing things for the court in that decision was that neither the majority nor the concurrences even mentioned Masterpiece. It was certainly mentioned in the dissents, but they didn't even feel the need to say, I know we did something completely different recently, last month, but here's why it's different. They didn't even get into that. So I don't think it can be reconciled. I think, Adam, your theory about how the court has maybe moved in a different direction with respect to this administration is an interesting one. We'll see. We'll see if we're going to get any more decisions. We need to have any more decisions that would either approve or refute that theory.
Well, it would rely on a 4-member liberal wing plus the chief, and we've lost, sadly, a member of the liberal wing. We probably could have acknowledged in the context of any discussion about the Supreme Court the terrible loss of a giant of American jurisprudence, both as a litigator and as a justice, and of course the giant of the ACLU. And that does, fundamentally alter where the court is going. Let me actually ask that question, just pause on it for a second. In the summary of last term's cases, we had 154 and 272s. The 2 dissenters were Ginsburg and Sotomayor. Now we've lost one of the dissenters, and there's good reason to think that Amy Coney Barrett will come on the court, which makes it look like in some ways an 8-to-1 court. Am I missing something in that analysis? I'll take that resounding silence to mean no.
I think it depends on the case, right? I mean, as you said, some of them were 5-4, others are 7-2, and even in the 7-2s, some of the other 2 were equivocal, I think. So it depends. Would be my answer.
Laurie, speaking of the stray comments in Masterpiece, there were also some comments in Fulton that your side said spoke of anti-Catholic animus. How much do you think that figures in the case?
I think it certainly doesn't help Philadelphia. When you have the mayor and the city council and the commissioner who's meeting with the Catholic Social Services head and making the decision there, making those kind of statements, it certainly doesn't help Philadelphia. Unlike Masterpiece, here you do have a record of the city of Philadelphia having changed its policies, acknowledging that it's now updating its contracts in response to a claim of religious objection, and not being able to really clearly identify exactly which policy it is that they were relying on all along. And so I think you do have some factual differences here, and it'll be interesting to see where the court decides to go with all of that. One other piece of it, which you have touched on, is what happens with Employment Division v. Smith. And just to touch on that for a moment, this is a case that has been understood for a long time as a majoritarian case, essentially saying whatever the legislature does, we're just going to look at if it's neutral and generally applicable. If it's across the board, if it is, then religious group, you're out of luck. And of course, that is a rule that is going to disadvantage minority faiths. It's going to disadvantage those whose religious exercises are not well understood. The lawmakers may have, intentionally decided that they were not going to respect a minority faith, or they may just have not understood how a concern about, say, wearing a religiously mandated beard was going to be impacted later on down the road. And so while I know it comes up in this particular context in the case of Fulton, it is really interesting to see where the court is going to go with that, and if it is going to revisit Smith and open the door to some future considerations of these kinds of cases where perhaps the government does have a neutral law, perhaps you don't have the evidence or don't have strong enough evidence of discrimination, and yet the court still has to grapple with the question of, is there a burden on religious exercise and how can it be justified?
Now, I confess I could use some help here because I don't really understand the cross currents. Employment Division was written by Justice Scalia. It did involve a minority religion, and yet it seems that in some ways the valence is flipped. And I'd welcome thoughts from anyone about what accounts for that flip. Dan, do you have any thoughts? I'm sorry, please.
I'll note here, and I'll let somebody else do the talking as well, but Smith, even though it's a Scalia case, was actually criticized from both the right and the left. When RFRA was passed, which was repudiation of Smith, it had no dissent in the Senate. I think it had 3 no votes in the House. It was signed into law by President Clinton. I don't think most of us can even remember when Congress operated like that, but the condemnation of it was really across the board and across the political spectrum.
Fair enough.
Yeah, that's true. I think things have shifted in a number of ways. I think now religious claims, free exercise claims, and statutory and constitutional free exercise claims are taking a form that they never took before. And I think that explains part of the shift. As far as what would happen with respect to religious minorities if the rules were changed, again, I want to return briefly just to the Fulton case and mention the fact that there have been agencies that have been performing these services, these government services with taxpayer dollars, that have insisted that they won't certify as qualified families who aren't Christian. And there's a case in a couple cases in South Carolina, not just who aren't Christian, but who aren't the right type of Christian. And so I don't want us to be under the illusion that a dramatic shift here is going to be a watershed moment in favor of religious minorities. What is being claimed here is a right to discriminate, and so that is a right that has been used in cases just like these to discriminate against religious minorities.
So before we turn to questions, we've laid out a lot of data points, general data points, individual data points about where the court is on religion, where it is on Muslims in particular. They seem to show a pattern, but I guess I'd just like to go around the table, as it were, and ask whether that pattern is an artifact of the fact that many of these cases come up in contexts where the government is apt to win to begin with. National security was mentioned. I think of the Iqbal case, the Ziegler case, similarly. Muslim detainees involved and they don't win, but is it because they're Muslim or is it because of the context of the case? Maybe I'll ask Asma to start and just give me your views on, having heard all of this, can we make a case that the court is hostile to Muslims?
Well, I think just to go back to the earlier discussion topic about the shift, I mean, I did want to note that I think what I'm seeing is also, it's not so much a question of has it moved from minority rights or majority rights, but I think it's because many conservative Christians, most of us think of as a majority, see themselves as essentially the new minority. I think that kind of goes back to Lori's point about the shifts and the way religious freedom was talked about and the bipartisan coalitions that used to be sort of backing RFRA and the free exercise clause, and just how that has shifted so that it's less bipartisan, and that in turn is sort of a reflection of a culture that many conservative Christians think is essentially positioned against them, and that they're now the powerless, or maybe not so much powerless, but definitely a despised minority. And so kind of like taking on sort of the tactics and that minorities, typically other minorities, people were used to thinking of as minorities, would use to protect their interests, and now something that they think are suitable to their interests as well. On this question of bias, I mean, I've written an entire book called, it's called When Islam is Not a Religion. Inside is America's Fight for Religious Freedom. And in it, I mean, I spend almost the entire book talking about what I see as absolutely sort of a trend that in religious freedom discourse and law that is prejudiced against Muslims. I mean, I do make a distinction in the book and in general my thinking between the Supreme Court, where I think some of these more sort of nuanced interpretations that we talked about today are at play. But there are a number actually of empirical studies that have shown that in the lower courts, there absolutely is a tilt in favor of Christians and against Muslims. And so, the most recent study was in 2012. So I think that there's been certain sort of evolution in the jurisprudence that might, I think that requires us to look at some of these cases again and do another study. For example, the Ocentro decision 2006 that required that the court, that the government sort of prove its point about compelling interest to the person requires a more fact-specific inquiry that kind of helps to get in the way of judges essentially applying stereotypes in cases involving Muslims. But that said, again, the empirical evidence does show that, I mean, at least from 2012 and before that, the studies that were conducted, that there is in fact this bias. And I think the other thing that I'm really sort of interested in, I think that if you really look at a lot of sort of the discussions among law and religion scholars and activists in this space, is that the fact that the law in the space has become almost sort of inextricable from the bigger sort of cultural and political questions around religious liberty. I mean, and in that space, in that arena, and sort of like the bigger national discourse, the politics, I absolutely believe that there is a very explicit tilt against Muslims. I mean, all you have to do, I mean, a book offers like, a laundry list of examples of very prominent politicians, including, presidential candidates who very like blatantly made that distinction between the religious freedom they think is worthy of protection and people whose religious freedom they don't think is worthy of protection. And so my concern really is just about that space where those two things meet, with the law and the political discourse meet, especially because the latter is so strongly sort of tilted against Muslims.
Sirine, what do you say? Have what we've seen, and taking the point that what's out there in society, what's out there in the lower courts, you may be able to make a very compelling case. Can you make the same case at the Supreme Court?
I mean, I think that you can, because I think that if you take the combination of the way that the court is treating free exercise cases and the way that it's treating Establishment Clause cases, like it essentially is flipping the point of these provisions on its head. Like when you think about why the Establishment Clause exists, it exists because this country was founded on this idea that there might be a plurality of religions, that people were fleeing from persecution from other places, and that those should all, like, there shouldn't be a favoring or disfavoring of one way of practicing religion or another, or even no practice of religion. And I think that when you put together the way that the court has ruled in cases like Hobby Lobby and Masterpiece Cake Shop, with the way that it ruled in the Muslim ban cases and also in the sort of the 10 Commandments type cases, what you get is a jurisprudence that is supposed to be protective of a pluralism and minorities, that now instead is being used to, promote the majority religion because of this kind of concern that things are shifting or changing, or that it's no longer as clear of a majority. And I think when you look at it in that context, it really isn't a surprise that cases that sound in sort of equal protection principles, almost like the Muslim ban case, are treated differently by the Supreme Court than cases that are about a baker who just doesn't want to bake a cake for a gay couple because of his Christian beliefs. I think that you can actually still make that case, even if there are nuances where you can distinguish the reasons for the holdings.
Dan, does that summary sound about right?
Yeah, I think so. I was nodding. Yeah, I agree with all of that. I think the court has not a great track record on treating all faiths equally, and whatever one might think about the cases in which Muslims have been litigants, and I think again bad track record there. On top of that, as Sirine said, it's the Establishment Clause exists to protect Muslims and other minority faiths. And as that goes down, so to go the rights of minority faith adherents.
Laurie, what's your take on this bottom line question of whether the Supreme Court treats Muslims differently than Christians?
I'm going to disagree. I don't think it does. And that's not to say that I agree with all the decisions they've made in cases involving Muslims. But I think that rather than reducing it to Muslims versus Christians, if you look broadly at what they've done, look at the case where they're protecting a Muslim prison inmate, look at the case where they're protecting a Buddhist prison inmate, look at the case where they're protecting a Brazilian spiritist sect. It's not just Christians here. And I think that, and I hope, with a lot of lawyers on the line, my plea would be to look at these cases and frame these cases in the terms that the court has been welcoming to, which is free exercise cases, which is RFRA cases and RLUIPA cases, being aware of the court's, concerns about procedural issues and how it's going to resolve those. And I think that going forward, if claimants are able to litigate those claims as a free exercise claim, demonstrate how minority rights are being disadvantaged within the free exercise context, I think that there is real room and promise for success on those kind of claims.
Well, this is such a terrific discussion. We promised we'd leave time for questions. Assuming we have questions, Alameen, let's have them.
We don't have any yet, but I have one. And I guess it's just to go back to the Tanvir case and talk about, what we expect to be the outcome there. I'm drawn to Sirine's legal realism, so I want to at least have her kind of start. But I'm interested sort of what everyone thinks about, how this case is going to come out, because, Asma got at the tension there that, the court has been very hostile to the sort of national security claims, and opening the door to refer suits, in this case is going to benefit these three Muslims, but, has a lot of implications for other kinds of cases. So kind of curious to hear where everyone stands on that, and Sirine to start.
I mean, I think that the Tanzim case is really interesting because I think it's sort of like a focal point of many hostilities of the Supreme Court, right? Like if you think about the Bivens case law, for example, and the way that that's evolved over time, and the court's hostility to sort of allowing people whose rights are really kind of egregiously violated by government officials a way to get a remedy, and kind of the progressive sort of like diminishing, hey buddy, I'm so sorry. 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 I'm sorry, this is a massive fail by my husband.
I want him to pay it too.
So in a way, it's very difficult to see this case as being just purely about RFRA, right? Because it does implicate a lot of other places where the court has shown hostility to these kinds of remedies by people who are aggrieved and who don't have. And it's really unfortunate because I think, for example, in the detention context, it kind of allows for a certain impunity on the part of government officials. And so that, like, my first reaction to the Tanzim case has always been more about that really than about, and how it fits in with that sort of hostility of the court to allow damages remedies in these kinds of contexts. But I think that it doesn't help that the plaintiffs are Muslim. It doesn't help that it's a national security issue. And I also think it's not surprising. I mean, we talked earlier about how the national security element was used to sort of explain the reasoning in Trump versus Hawaii, but it's not surprising because this country has set up a structure where national security is kind of equated with people who tend to be Muslim or who tend to be, from Middle Eastern countries or kind of have. And so I think those things conflated together don't make me very optimistic about how the court is going to rule in that case, even though it's RFRA and it's religious liberty. That's really kind of the crux of the claims in that case.
Other thoughts? I mean, another thing that makes the case open to the court's kind of sterile textualism is that the basic statutory question is, what does the term appropriate relief mean? And does that encompass money damages? And you could imagine a very mechanical, wooden kind of decision that doesn't touch on any of what we're talking about here, as a dry recitation of the facts, and said Congress didn't mean for appropriate relief to include money. Is anyone optimistic about the outcome in the case? Does anyone want to elaborate on their pessimism?
There was another question from, or there is a question from Irfan who raised his hand. I'll let him take it away.
I'm actually interested to hear the response from this one, but my question was more so, Adam, you had mentioned a few times that Lori and Dan had disagreed on a few things. So I'm actually more curious to hear what some of the panelists might disagree on and just trying to get a sense of what that disagreement is. So.
You wouldn't know it, but they disagree about just about everything. You each want to sketch out the shortcomings in the other person's arguments?
Well, maybe I'll take a different approach, which is I agree. It is true that we disagree on a great many things. I think almost anything under the Establishment Clause we probably disagree on. I think there's a fair amount that we actually agree on with respect to the Free Exercise Clause and related statutes. Where we part ways, I think, and I don't want to speak for you, Laurie, but on free exercise is situations where the claim of free exercise ends up harming third parties. That is where I draw the line, and I don't think you have a free exercise right to do things that then impose significantly on others who aren't involved. But in situations where that's not present, so we talked about the example of prisoners on death row seeking spiritual advice. I think we're in complete agreement.
Yeah, so, definitely agree with Dan on that set of cases. And I think that's right. We disagree on the Establishment Clause. We've heard some of that here this evening. I think that the Free Exercise Clause is and ought to be the place where we look for protection for minority faiths and for religious discrimination. I don't think that changing the Establishment Clause takes away those protections. I think it merely pushes them back into the free exercise category, which is where I argue that we ought to be. On the issue of what's been called third-party harms, that's a really large and nebulous thing. Prison administrators try and make those claims to say, oh, well, there's security risks, so that's a third-party harm. In those cases, I think you need something more precise. And I think the compelling interest test gives us a way to really analyze those harms and analyze how governments ought to do that balancing. I do want to take just a moment and turn back to the Tanzania case. I would love to see the court go what I think is the right way in this and recognize that these gentlemen are able to receive compensation and pursue their case and even get their day in court to be able to prove their case for being on the no-fly list for up to 4 years without apparent justification. But I am I am concerned, given the court's earlier ruling in Sossaman under the Religious Land Use and Institutionalized Persons Act, where they declined to find a damages remedy there. I think that ruling was wrong. I wish they'd gone the other way. I'm hopeful they will go the other way here, but we do have, some history there. So we'll be watching very carefully that argument and to see which way the court might be leaning.
On the question of balance, just I think it's important to point out that everybody here sort of believe that there should be a balance when it comes to religious freedom protections. I think sometimes the people who advocate in favor of conservative Christian claims are sort of interpreted as people who think their religion just sort of trumps everything, that it trumps, compelling government interest. And the reality is that everybody here believes that there should be a balance. I think we draw the line somewhat differently, but none of us believes that the religion trumps all other interests.
Alameen, do we have more questions?
Not yet.
Okay, so I have one, and it's to Laurie, and it pivots off of something Dan said, and it takes us back to RFRA, which you correctly said was supported by bipartisan majorities as a federal law signed by President Clinton. But when states started passing RFRA laws with essentially identical text, the political reaction was different because there was the feeling or the fear among some liberals that they would be used as a pretext for discrimination, that they would be used to exclude, in particular, gay people from public life. What's your reaction to that?
I think that, it's been really unfortunate to see the breakdown of the bipartisan agreement over RFRA. This was designed to be a law that protected everybody. And it's really interesting if you look at the history of how that came together. There was, initial discussions about, well, let's have this carve out or that carve out. And they realized the only way to get it done is if they said no carve outs, we're going to protect everybody. And I wish that spirit had carried forward. There's been attacks, as exactly right, at the state level against RFRAs. About half the states have some sort of RFRA protection, and we have not seen this parade of horribles come to pass. And so I think, unfortunately, RFRAs are getting scapegoated or blamed for fears and concerns that people have about a lot of other things. And RFRA statutes have turned into a flashpoint there, but their basis and their intent is really to be able to protect everyone. And I would be hopeful that there is a way to recognize that going forward.
All right, unless we have more questions, maybe I'll solicit concluding thoughts from anyone who wants to offer some. We've covered a lot of ground. Is there a way to wrap up, or shall I just thank each of you?
I guess if I can say one more thing, Adam, is that I really do think that we don't pay enough attention to the importance of having a diverse makeup in more than whether people are liberals or conservatives on the Supreme Court, and how deeply that impacts how we think about those. Because a lot of these questions of legal interpretation are not actually ones that are not informed by people's histories and their experiences. And I think an example of that, very much outside the religious liberty context, but I think brings this home, is this idea that the only person who understood why finding an active warrant against someone after you pull them over in a bad, let's say, racist police stop that has no reason for it, is something that impacts people in certain communities in a really devastating way. And it was because of her life experience and the way that she had grown up that she could actually access why that was so damaging and why that should be considered, not a reason to justify the initial stop, which was unlawful to begin with, where, someone like Justice Breyer, for example, joined the court's conservative majority to find differently on that question. And I think that, losing someone like Justice Ruth Bader Ginsburg, who I think might be the only person on the court who had an impact litigation background as opposed to a prosecutorial background, I think all of those things are really important and relevant to the topic that we're talking about today, which is that the makeup of the court and where the justices come from, in addition to their judicial philosophies, is actually something very important that we should also kind of understand informs the way that they would think about a certain question, depending on who the plaintiff is or where it comes from, and how that relates to, how they grew up in the world. And I know that's slightly off topic, but I just wanted to make that point because to me, it's actually very related to these questions about whether the court disfavors or favors certain groups. I don't think that it's an overt bias. I just think that it's an unfamiliarity and a fact that, the makeup of the court tends to be very homogeneous by and large.
I think it's a terrific point, and it's not a bad place to end. We're about to have, if Judge Barrett becomes Justice Barrett, a court with, depending on how you count it, 6 or 7 Catholics on it and 2 Jewish members. That's odd in one sense, because for many years we had only white Protestant males on the court, but it's also odd in a second sense, whereas there's at least a school of thought that it would be very tough to get an atheist or a Muslim on the court. We don't know because it hasn't happened. But these arguments are being made, as you say, to a certain set of people. So listen, thank you everyone for joining us. Please please join me in thanking this fabulous panel. This was a really good discussion, and we virtually applaud you.
Thanks, Adam, and take care, everybody.